Welcome to my presentation on the Australian Consumer Law Part 3.5 Manufacturer's Liability for a Safety Defect. The following presentation makes no promises as to the correctness or accuracy of the information contained therein and is intended only as a study guide or as a reference point for discussion, and also as a demonstration of the usefulness of Decisive produced by Ozthink Software and Ozthink Consulting in mapping out these kinds of issues. So, ACL Part 3.5 Liability of Manufacturers for Goods with Safety Defects. The first question you really are going to ask is whether P, which is the plaintiff, and that's typically the person who has suffered injury or damage and loss, but we'll see that it's a little more complicated than that. But let's say P for plaintiff. Does P have a good cause of action against D under the manufacturer's liability provisions? So if that person does, then we'll see what follows. So to answer the question of whether there is a good cause of action, you first have to go through a few steps. First of all, pursuant to ACL Section 138, subsection 1, the manufacturer supplies the goods in trade or commerce. If yes, then you ask whether the goods have a safety defect. And let me just change this little bit here. Okay. You ask then whether the goods have a safety defect pursuant to ACL 138 subsection 2. And if so, then you've got the two out of three components for a good cause of action. The last component we will address later, that's to do with injury and suffering of damage or loss. So to go back to the question of whether the manufacturer supplies the goods in trade or commerce, we will have to ask whether, first of all, the goods, product X, the product in question is a good, and we refer to the definitions in ACL Section 2 for that. Whether D is a manufacturer, ACL Section 7 gives us the definition, and one case that may be relevant is the case of Glendale and ACCC, where it was held that D is the manufacturer, that a company is a manufacturer if it packages the product or the good in question, or if it assembles and labels the product in question as its own. So if a company gets a product and packages it or labels it or assembles it and under its own brand, then it is considered to be the manufacturer for the purposes of the Australian consumer law. So if the product is a good and the defendant is a manufacturer, then you're going to ask whether the defendant supplies the product in trade or commerce. Is the defendant a trading corporation pursuant to ACL Section 4, then it's held to be in trade or commerce. If we're not talking about a corporation, or alternatively, if D supplies a good for reward, it does so in trade or commerce. So basically, if there's anything to do with buying or selling, you can pretty much guarantee it's going to be in trade or commerce. So on to the next question. Do the goods have a safety defect? This is really the pivotal question, and this is where a lot of the effort will go when ascertaining whether there's a good cause of action. Do the goods have a safety defect? So, first of all, you ask, is the safety of the goods not such as persons are generally entitled to expect? And, sorry, just minimize that by mistake. Is the safety of the goods not such as persons are generally entitled to expect? Well, there's a series of considerations in ACL Section 9, subsection 2, the manner in which and the purposes for which they've been marketed, their packaging, the use of any mark in relation to them, any instructions for, etc., what might reasonably expect to be done with or in relation to them, and the time when they were supplied by the manufacturer. So all of these are just really basic considerations. I won't go into them, it's just common sense sort of stuff. Now, if the safety of the goods is not such as persons are generally entitled to expect, then it is held that the goods have a safety defect. If if it is held that the goods have a safety defect, there are a couple of other things to bear in mind. First of all, pursuant to section 9 subsection 3, an inference that the goods have a safety defect is not be made if safer goods of the same kind were supplied afterwards. So if goods of a certain kind were supplied, a product was sold, and then it was recalled and it was replaced with something that was safer, the court is not allowed to draw from that subsequent action the inference that the original goods had a safety defect. Similarly, if there was compliance with a Commonwealth mandatory standard, and the Commonwealth mandatory standard basically wasn't good enough, that is, the mandatory Commonwealth standard did not have the safest possible standard having regard to the latest state of scientific or technical knowledge when they were supplied by the manufacturer, then similarly an inference that the goods have a safety defect is not to be made. So if the manufacturer complied with Australian law, with the Commonwealth standard, and the product was nevertheless held to have seems to nevertheless have had a safety defect, you can't draw that inference. Now, interestingly, if this is the only defense that was raised by the defendants, that there was compliance with the Commonwealth standard, yet the and were it not for compliance with the Commonwealth standard, the product would have a safety defect, then the Commonwealth can actually be drawn in as a defendant and can be made liable. So if D raised no other defense, so this is ACL section 148 subsection 1, then the next question is whether D followed the instructions of 148 subsection 1 subsections A to B by giving the Commonwealth a prescribed notice of the action and of that defence, and a copy of the person's defence in the action. Doing so, pursuant to 148 subsection 2, makes the Commonwealth a defendant in the action. And, following that, if the court finds that the plaintiff would, but for the defence referred to, but for this defence that compliance with the Commonwealth standard was basically had a lot to do with safety defect, then the Commonwealth will basically be made liable. Read more about that in section 148.3 subsections A to C. Okay, so we've got the point now where we've established that we've got it's trade and commerce. The manufacturer is capable of being sued. Obviously, we're going to assume that the plaintiff can sue, and that there's a safety defect. That's the central question. So, assuming that we have all of those components, we then move on to a couple of other brief considerations before going into the third component, which is all to do with injury. So, if pursuant to section 144, if two or more persons are liable under Division 1 for the same loss or damage, they are jointly and severally liable. And 145, if a law of a state or territory, if someone dies, then you refer to the law of the state or territory. The ACL doesn't address that, but we'll see a little bit more about that. So moving on to, so remember that the question is whether there's a good cause of action. That's really the pivotal question. And if there's a good cause of action, ultimately what you want to know, both as defendant and plaintiff, is whether someone's going to have to pay a lot of money, whether they're going to be damages. So in order to get that, not only does there have to be the components of a good cause of action, but the plaintiff has to follow the prescribed steps. So has the plaintiff commenced a defective goods action within the statutory limitation, which is 3 years, which we'll see a little bit more about in very shortly, and that's section 143. So to determine whether the statutory limitation was not exceeded, first of all, the action has to commence within 10 years of the supply, section 143, subsection 2. Assuming that it has happened within 10 years, then we'll ask whether the action was commenced within 3 years after the time that P became, or ought reasonably to have become, aware of the alleged loss or damage. That's section 143, subsection 1, subsection A. In addition to that, that the plaintiff became aware of the safety defect of the goods within 3 years, and also within 3 years that so that's 143(1)(b), and 143(1)(c), that the plaintiff became aware of the identity of the person who manufactured the goods. And if all those three things, became aware of the alleged loss or damage, became aware of the safety defect of the goods, and became aware of the manufacturer's identity, then the statutory limitation period has been met. Now, let's say that the plaintiff does not know the identity of the manufacturer. Well, section 148 of the ACL addresses that. Was it 148? 147. My mistake. 147. So, 147 subsection 1 subsection B states that the plaintiff, if the plaintiff is not aware of the identity of the manufacturer, the plaintiff may basically write to the supplier, so the person that you bought the product from, asking the supplier to give you the details, details with which you may identify the manufacturer. So if you don't know who made it, but you know whom you bought it from, you write to the person that you bought it from and ask that person to supply the details so that you can follow the chain of supply back to the manufacturer. And if you fail to do that, then it's just held to be that you don't satisfy 143 subsection 1 subsection C, and so you can't proceed with your cause of action. So you write to the supplier, and if the supplier within 30 days does not give you the information that you need, then the supplier, so that's 147 subsection 2, then pursuant to 147 subsection 2 subsection A, the supplier, assuming that we're talking about the supplier is the person to whom you made the request, and then subsection B, subsection B, the supplier can be taken for the purposes of this action to be the manufacturer of the goods. So if you buy something from a supplier, from a store, a supplier of some kind, and that item turns out to be defective, they have a safety defect, etc., etc., and you go back to the store and you say you want to sue the manufacturer, and the supplier fails to comply, fails to provide you with the identification details, then you can take the supplier to court and not have to be left in limbo trying to find the manufacturer. But of course you have to follow these steps, and if you don't follow the steps, then that's where it ends. So assuming that the plaintiff, have commenced a defective goods action within the statutory limitation period, you then move on to ask whether the defendant has a valid defense. So at this point it's been established that the plaintiff has a good cause of action, so now we're asking about defense. Oh, one other point about cause of action is that if more than 10 years, or presumably more than 3 years for the other elements have passed, so if it's now outside the statutory limitation period, I believe that Supreme Court Rules of Victoria, Order 36, Section 1, Subsection 6, holds that the court does have the discretion to ignore the statutory limitation period, but again, that's for the court to decide, so it's not a given. But it is worth bearing in mind if you're looking at this cause of action, that if you've exceeded the statutory limitation period, the Supreme Court rules do give the Supreme Court, and presumably the county court rules are similar, the court will have the authority will have the discretion to decide whether you can proceed with your cause of action, even if it's outside the limitation period, the statutory limitation period. But assuming that it is within the statutory limitation period, now we're looking at defences. So, first question is, so there are all sorts of different products. One of the unusual products is electricity, and so if we're talking about electricity, then the question is whether the safety defect in the goods was not present. So the defense is basically that there was no safety defect, or if there is a safety defect upon inspection of the product now, it wasn't there at the time. That's pretty much the defense. And so with something like electricity, the legislators saw fit to include this bit saying that if the defense is that the safety defect did not exist at the time, then it's at the time that the electricity was generated, because that's first it's generated and then it's supplied. But we don't really need to look at that, it's pretty obvious. Secondly, so if we're looking at anything else, so basically tangible items for the most part, did the safety defect in the goods that is alleged to have caused the damage or loss not exist at the time the goods were supplied by the actual manufacturer? And that's 142 subsection A. I assume that actual manufacturer is the person who's held to be the manufacturer, or the company that's held to be the manufacturer that we talked about earlier. So if there's if that first offence, that the safety defect didn't exist, doesn't pass, can't be made. Alternatively, 142 subsection B, the defendant can argue that the goods had that safety defect only because there was compliance with a mandatory standard for them. Alternatively, ACL section 142C, that the state of scientific or technical knowledge at the time when the goods were supplied by their manufacturer was not such as to enable that safety defect to be discovered. So I suppose if we're looking at a drug or some new device, then we're looking at the state. So for instance, if it's a drug or some new device, then perhaps it might be that further research needs to be done before one can conclude that there is such a safety defect. So 142C is probably going to be of particular interest if the product in question is a drug. Heads up. If we are talking about that sort of thing, then 147 subsection 2. We're going back to that unusual instance where the manufacturer is not identified, and in fact instead the supplier is being sued. Then this is not a valid defense. That is, the state of scientific or technical knowledge is only a valid defense with respect to the actual manufacturer, not with respect to a supplier who supplied the goods. So I suppose this is aimed at people to prevent or discourage people from selling all sorts of shoddy goods that were produced, I don't know, on the black market or maybe in China or something like that. Next, the ACL section 142D, that the goods had that safety, if we're talking about goods that were bundled in or were a component of other goods, comprised in other goods, then the question is whether the safety defect was attributable only to the design of the other goods, so 142D1, or basically if you can blame it from the defendant's perspective, if you can blame it from blame it on the on what the product in question is mixed or bundled with. So the design of the other good, the markings on the other good, the instructions, the warnings, etc. So those are the possible defenses. But assuming that there isn't if there is a valid defense, then that's where it ends. But assuming that there's no valid defense, then we get to talk about damages. So the first question is whether we are talking about loss or damage that's covered by workers' compensation or some other scheme. So if the plaintiff has already recovered or could recover an amount of money for the loss and damage suffered under a workers' compensation scheme or an international agreement, so that's 146A and 146B respectively, then the damages don't apply. If you can get money from the workers' compensation scheme, you have to go there. You can't take it to court. I suppose the court looks upon that as double dipping. If money isn't available from a workers' compensation scheme or an international agreement, then we're looking at the various kinds of claims that can be made. So the first one is whether, as 138, whether the person has suffered injuries. If the person died as a result of the injuries, then basically state law, or the law of the state or the territory takes over. And another little interesting twist is that if there is a person who suffers loss or damage because the injured person dies, so we're talking about two people here. Let's say P is the person who suffers the injuries and dies, and Q is someone who's closely related to P. Then if Q suffers loss or damage because of P's injuries or death, because of P's death, then then Q may recover loss or damage as well, but only if the loss or damage does not come about because of a business or professional relationship between the person and the individual. So, for instance, if your business partner basically dies because of a safety defect in a product, you can't sue for loss or damage to your business, but if, I presume, if you are, let's say, married to a person and you are financially dependent on that person, then it might be a different story. But anyway, the relevant provision is 139, subsections 1E and 139 subsection 2. So that's the first kind. So 138 and 139 deal with suffering of injuries, so personal injury. Section 140 of the ACL deals with other items, other goods, basically household domestic items. So I suppose it might be something like if you buy a toaster and the toaster causes a fire, then all of the other items in your kitchen, of course, are going to be damaged or destroyed. And so section 140, subsection 1, subsection C and D are the provisions that you're going to look at for the for compensation of that kind, for those sorts of goods. ACL section 141 subsection C, from C all the way through to F, talks about land, buildings, fixtures, stuff like that. So similarly, if you again, I suppose if you buy a faulty toaster, it could be a toaster, microwave, it doesn't really matter. Whatever it is you buy, if it causes damage to your land, buildings, or fixtures, and I can only assume there's going to be something that starts a fire, or maybe something that explodes, whatever it may be, 140 is for your household goods, your food, your appliances, that sort of thing. 141 is the land, buildings, or fixtures. So if there's a fire and your house burns down, it's 141, subsection 1, subsection C, that you refer to for those kind of claims. And so the provision, the stipulations of this provision of 141 are that it's land, buildings, fixtures, that it's ordinarily acquired for private use, that you intended to use it for private use, and that you suffered loss and damage as a result. Similarly, with 140, it's household items that you actually intended to use. So you couldn't make that claim under 140 if you had bought a whole lot of ingredients and you're a commercial cook. It's not that sort of thing. So that's pretty much it for the topic of liability of manufacturers for goods with safety defects pursuant to the Australian Consumer Law Part 3.5. I hope that this has been useful to you. A PDF of this map will be available in the link below. And please feel free to leave me comments or contact me. Let me know whether this has been useful to you and whether you'd like to see more maps like this. So feel free to comment down below. Get in touch with me. Thanks for watching, and I'll speak to you soon. Bye.